But I do not know.
Now, where is the provocation here again?
My lord.
Where is the provocation? Even in the cross, where is the provocation? Well, because, you see, section 300
My lord.
defines murder and the exceptions due to which it can be said that it is not murder. Exceptions are there. Now 304B will have to be, 304 will have to be read in relation to the exceptions to 300.
My lord.
So where is the provocation? The provocation is a sine qua non for invoking 304.
And my lord, in order to fulfill the ingredients of section 300, my lord, it is my humble opinion that the intention has to be proved.
He's saying that he's trying to shoot the television.
Oh,
If-
you're trying to say it. You are saying
Yeah,
that
and
he
that-
tried to shoot the television, but he shot
Yes,
his
and that-
son by mistake.
And that, my lord, it is the case of the appellant here in that he had no intention to shoot at his son.
That
And
is-
that intention has not been proved by the prosecution, my lord.
See, in his
You see,
at the time of consideration of charge, he not getting, he tried to shoot the television.
that is afterthought.
That's his fear.
You see, that is what you want the court to believe.
My lord.
You have got to show that it is a plausible explanation. Just because you saved something does not mean it is the gospel truth or we should accept that. Now, say a person with normal common sense,
My lord.
okay, though it's not very common, this TV, you're trying to shoot a TV, and the TV you said is behind your son.
My lord.
How did you expect to shoot the TV without hurting your son? You expected the bullet to curve around your son or something?
No, my lord. With your lordship's permission, my lord, yesterday we have looked at the
Map.
map.
Yes.
And the doorway to the bedroom from which the appellant had took out his gun,
Ah,
and the kitchen table, that was not in direct line to the TV, my lord.
not in direct line. Yes. So the TV was also smashed. I mean,
Yes.
yeah,
Yes.
the
TV was destroyed.
TV was destroyed by the gun. Your son also died in the process.
Yes.
How many shots were fired? One shot.
Only one shot.
One shot. Double barrel gun or single barrel gun? What is it?
It only says SBBL gun.
SBBL. It's a single bore.
Single.
Bore. So it's a single bore gun. Now, so you see, supposing now according to the map,
My lord.
this is the sun
My lord.
and this is the TV. I think according to the map that.
My lord.
So if I'm going to shoot here,
Yes.
why should this guy suddenly come and protect the TV or whatever it is? Why should he suddenly come here? Or is it that you pointed at him, he ran away, and then when he reached near the TV side, then you shot?
My lord.
You've got to, you see, there has to be some kind of, is it possible? Is it a practical thing to do? If a person is pointing away from you, you go directly into the line of fire.
If I may take your lordship's
I've never heard of
yes.
this. Supposing a person is throwing a knife, you are standing there. Will you go and stand right in front of him?
that is there, my lord.
Then
If your lordship could kindly come to page number 5.
page 5. Yes, page 5.
This is the 313 statement.
Yes.
Put to the appellant the question: do you
Yes.
have anything else to say in your favor?
Yes.
The answer, if I may read. The fact is that I have no intention to shoot my deceased son, but I intended to shut down the TV by the said SBBL gun because my deceased son used to play the TV with a high volume while his sisters were studying. I do not know how my deceased son came between the TV and me while I shot the TV. I also would like to state that the case IO recorded my statement falsely. So, my lord, the appellant himself did not know how his son came in between himself and the TV.
But
And
you
yes.
see, why should you bring out the gun to shoot the TV? He was having dinner. You scolded him. You go and switch it off.
My lord.
Why did you bring out the gun? He was having dinner.
And my lord, herein,
Imagine,
Yes.
no, you imagine you having dinner.
Yes.
Your father suddenly comes with a gun. To do what? To shoot the TV. Why? Is it logical? I don't think that's what a normal person would do. If you're having trouble with your son or something, might be a very bad fellow, but he was having dinner. Your son's having dinner. Will you say TV was playing loudly? Will you take out a gun and shoot your own TV? You have to pay for it. Anyway, then what else?
my lord. My lords, the reason that I have stated that the ingredients of Section 300 has not been fulfilled.
And please look at this.
Yes.
PW2 says doesn't make sense.
My lord, however, my lords, my case is that the ingredients of 300, Section 300 has not been fully complied, my lord. The ingredients have not been proved. And my lords, yesterday I have submitted 2 citations, in one of which it says the ingredients of Section 300 has to be satisfied, my lord. The ingredients.
There's a thing called res ipsa loquitur. The
Yes.
thing speaks for itself.
Yes, my lord.
Then
And my lord, I even have another ruling saying that the accused has merely to put a doubt, and that doubt and that doubt has to be satisfactorily explained.
no,
Satisfied by
and the
the
court has
prosecution.
to the court
I
has to accept it.
I have Supreme Court ruling to
You
the
please
effect,
bring,
my
you
lord.
please bring.
My lord.
We'll differentiate all the Supreme Court rulings.
This is 2021 volume 12 SCC 550.
Not in a, this is not the way. 2021,
2021 volume 12 SCC page number 550.
515,
My lord. 550.
550. Paragraph
7.
7.
If I may read. Paragraph 7. If I may read, my lord.
This is
The allegation that the appellant stuffed cloth in the mouth of the deceased was serious and specific against her. We are of the considered opinion that in absence of any question having been put to her in this regard under Section 313 CRPC, the appellant has been seriously prejudiced in her defense. It is repeatedly been held that the procedure under Section 313 CRPC is but a facet of the principles of natural justice, giving an opportunity to an accused to present the defense. The burden of proof on an accused in support of the defense taken under Section 313 CRPC is not beyond all reasonable doubt, as it lies on the prosecution to prove the charge. The accused has merely to create a doubt. So, my lord, in the instant case, the appellant herein had clearly stated that he had no intention. And that doubt, my lord, according to this judgment, that has to be proved by the prosecution. And that intention has not been proved in this case, my lord.
come to the evidence of PW5.
My lord. This is a page number 20.
Yes. Come after having dinner. Number 7, page 20. 1, 2, 3, 4, 5, 6 line.
Yes, my lord.
After
After having dinner, I, H. Lalwata,
H. Lalwata. I is the grandfather, the
Yes,
father-in-law.
yes,
Then H. Lalwata.
H. Lalwata, my
My daughter.
daughter, PC Lungtioy, this is the wife of the appellant.
And Lal Zikpui.
And Lazikpui, this is PW number 2.
Watched news on
watch
TV.
news on TV.
Ah.
Yes, they were. Yes, I have submitted.
Please
that.
read, please read.
Yes, my lord. While we were watching TV, my grandson Sizo Nunmoye came home from practicing football, and after that, I heard a loud sound of gunshot, and the TV we were watching also shut down immediately.
So where is the TV being destroyed?
It says here that it shut down.
Shut down does it mean destroyed? Supposing this computer screen in front of us, if it's shut
Right.
down, electricity goes, then it gets shut down. Does it mean it's destroyed? And please understand, there are 3 persons watching the TV when the shooting goes off.
My lord.
They would have been injured. It appears that those 3 persons who were watching TV have tried to make out a story that they did not see anything. But
PW 14. Television is 14.
okay, PW 14.
Page.
The hole in the TV screen in Exhibit C was the entry hole of the lead slug found inside TV. The weight of receiver is standard weight for a RSR 12 bow cartridge. Okay, so there was a lead slug also in the TV.
My lord. My lord.
But then,
Yes.
let us be very clear.
My lord.
You know what a single bore barrel, have you seen a bullet?
Yes, my lord.
It is a big round packet and inside the round lead pellets. Inside.
Yes.
Numerous ones.
Yes.
Depending upon the bore. Each
Yes,
one.
yes.
And so these bullets, when they come from the gun, they spread out. Small, it spreads out.
Yes.
Now, how it did not hit those other 3, I don't understand. Okay, but anyway, one hit.
Yes, yes.
How many pellets were inside that SBBL bullet? How many?
My lord, that has not been specified in the FSL report. It only says at page number 94.
Anyway, you see,
Yes.
he's angry with his son watching TV earlier. On that particular day, the son was not watching TV. It was the sister watching TV. It was the father-in-law watching TV. The son's grandfather, basically, another person. So there was no provocation on the part of the son.
My lord, it is in evidence that his son came home from football practice and he was unwashed and
So?
sat down on the table,
Correct.
and that his father reprimanded him.
So he went and took off his
So-
socks. That's what it has been said.
Yes.
Then
And
anything else?
and regarding this television set, this at page number 94, the FSL report.
94.
If your lordship could come to page number 91 first. Exhibits examined in serial number 3, one LG TV that is marked as Exhibit C. Exhibit C. So in page number 94, the result of the FSL report is given. Exhibit, with regard to Exhibit C, paragraph number 4. The hole on the TV screen that is Exhibit C was the entry hole of the lead slug found inside the TV. The lead slug is having a weight of 28.7 grams. So, my lord, the bullet has indeed destroyed the TV.
You see, like I said, they are not. You see,
Yes.
I'll say it in layman's terms.
My lord.
The SBBL
Yes.
has a big cartridge.
Yes.
Inside that cartridge, there are numerous lead pellets.
Yes, my lord.
Depending upon the size, they are different.
Yes.
Sometimes they are more than 20 also, less also, more also,
Yes.
depending upon the size. So, in effect, what comes out is numerous bullets from one bullet.
My lord. And there is also
And it spreads out.
yes.
This is used for duck hunting and all this also.
there is also, my lord, some bullets with only one lead ball.
Not in SBBL.
My lord, there is. My
SBBL, yes, there is also
Yes,
for
yes.
competition. So,
Yes.
if there was only one bullet, how did the TV get thing? and he died.
My lord,
Let
there
us-
is an exit wound and
Let us see the post-mortem examination.
yes, there is an entry wound and exit wound of the bullets. That yesterday I have submitted, my lord.
Okay.
And the very fact that, my lord, the nature of the bullets not being specified herein also, my
How
lord.
does it matter? Where's the provocation? Where's the provocation, first of all?
My lord.
There's no provocation. We want to help you, but where is the provocation? As per the law, where is the provocation? Just because you're dirty, you shoot somebody. He comes home dirty after playing football, you shoot him dead. Supposing someone shouts back at you, you shoot him dead.
My lord.
Where is the provocation? Please try to
Yes.
give a reasoned submission.
My lord.
You see, how can it be?
My lord, my main point of submission herein is that the ingredients of 300, my lord, this I will repeat again.
No,
Because
we have heard. There's no point. You see, we have heard.
And
We have heard. You bring.
Yes.
If you can have some other thing, there's no point. If you have got some other grounds, that's all. There's no point saying it over and over again, hammering it.
my lord, I still have one more citation to.
Yes, give
my lord.
us a citation.
This is
Wasting time, my lord.
1962 AIR 1962 SC 605.
Yes.
AIR 1962 SC 605.
Hmm.
Paragraph number 18.
Paragraph 18.
Yes, my lord.
Yes.
My lord, I will. The provisions of the Evidence Act, section 103, 105, those are provided. And just below, I will start from just below the next paragraph.
Yes.
The legal impact of the said provisions in the question of burden of proof may be stated thus. In India, as it is in England, there is a presumption of innocence in favor of the accused as a general rule, and it is the duty of the prosecution to prove the guilt of the accused. To put in other words, the accused is presumed to be innocent until his guilt is established by the prosecution. So, my lord, in the same thing, my lord. The prosecution has not proved that.
Look, one thing is this: you are guilty of having shot your son and killed.
My
That
lord.
is not even admitted by you.
My lord.
Your only case is that it is not murder. That is your only case. It is not murder, it is culpable homicide not amounting to murder. That's your case.
My lord.
But it is a proven fact that you shot your son inside the confines of your room, unless you can prove that some bullet came whizzing into your house from somewhere and killed your son and also the TV.
My lord.
That is not your case.
That I have no intention to shoot my son.
That is what I'm saying. There is no intention.
My
So, what is the end result of having no intention? The end result of having no intention is that it is culpable homicide not amounting to murder,
My lord.
and which might come under 304. That is your case.
My lord.
Okay. Yes.
Mr. Lordships, from what we can gather, my lord, as your lordships has already pointed out, there were 6 persons inside the room, and 4 persons were witness to this.
Who was the
incident.
sixth person?
My lord, there were 6 persons.
Acha, 6 persons, including the victim and the
appellant.
appellant.
Yes, my lord. And the other 4 persons, they heard a gunshot.
Actually, just one more thing. What about this gun? Is it a licensed gun that you
Yes,
have?
my lord.
License.
Yes, it belongs to the appellant's brother.
Oh, so it is not appellant's brother. The
Yes.
appellant's brother is not your gun.
The
Your
BW number 12.
Correct, but
Yes.
it is not your gun.
Yes.
Your cousin's brother gun is not your gun. Your
Yes,
grandfather's gun is not your gun. So your brother's gun cannot be your gun.
Yes, my lord.
That is what?
In respect to conviction with section 25 1B A of Arms Act, my lord, The appellant has nothing to say now.
I think the only issue here is whether he was trying to shoot his son and he shot his son and he died, or he was trying to shoot the television and accidentally
Yes,
his son
ma'am.
also got shot.
That-
I
that-
think that's the only issue.
That is my
So,
case, ma'am.
PP has to tell us that he was not
Yes.
trying to shoot the TV but the son. Those
That-
rest it's clear.
yes, yes.
And you were trying to shoot the TV while your daughter,
Yes.
wife,
My
and
father-in-law.
your father-in-law were watching the TV.
And my landlord.
Huh?
And my landlord.
And your landlord also. And while your son was having dinner.
My lord.
Why? Is it a normal thing to do? Yes.
So, Lordship, like I have pointed out, the facts of the case is that there was only one room. The incident happened in one room,
Yes.
and there were 6 persons inside it. And the 4 persons, they heard a gunshot. Before that, my lord, they heard the son and the father scolded the son, and the son had talked back to the father. This can be seen from the evidences of PW
Correct,
number.
correct.
Yes, ma'am. And after that, there was no argument as such, but the son had talked back to the father, and the father had lost his temper, and he went inside the room and grabbed a gun. And after that, they heard the gunshot, and the son fell down. Lordship will see that from the evidence of PW number 3,
Yes.
in the last page 16 from the last line, my lord.
And I immediately faced towards the kitchen. I saw the victim slowly collapse from his
Yes,
dining chair.
from his dining
From
chair.
his dining chair.
Yes.
Not from in front of the TV. From his dining chair. Unless he's Superman, he got shot in front of the TV, then came back to his dining chair and then fell off from there. Unless that happened.
Yes, Your Lordship. And if you see the map, my lord, which we have at page 102, the bedroom door and the dining chair is very far.
Correct.
And if he had really wanted to shut down the TV, my lord, he could have shut from the from the door, just near the door. But he came and stood near the PW number 1. I mean the deceased. And the chair is at number 1, my lord. So the intention was not to shoot the TV, and the story would have made more sense if the son was watching TV with loud sound at that time. However, the TV was watched by the other 4 persons. They were watching news. And we have the evidence of the IO.
Yes. Where?
Evidence of the IO is at page 35, PW 16.
PW 16 page.
Yes, madam. Page 35. In the last line, my lord,
Yes.
counting from below the page, my lord. During interrogation, he admitted to have shot dead his Zaununoya, stating that due to his being wayward, that that is Malsoma, rebuked him of his demeanors, and since he was not paying any heed
No,
to
but
his
then this
repeated
is a statement made to a police officer.
yes, my lord,
It's
but
it-
that was his first confession, my lord.
No, but it's a confession to a police officer is not
Yes, my lord.
admissible. in
However,
evidence.
that was what he has stated to the officer at that moment.
that is
And-
neither here nor there. That cannot be
In
accepted.
313, this is an afterthought. In the beginning of the trial, my lord, not trial, at the time of incident, this was the excuse he has given, that he,
No, it's probably correct also. Probably correct, but then we have got to show that there was a provocation, that section
Yes.
exceptions to 300 are attracted. Unless that can be shown, how can we come to different finding that it was not 300?
only confusion is how did the television also have a gunshot? If you look at the drawing,
can be,
no,
you see, it can be an afterthought also.
but it's a gunshot in
It
the
is a
television
gunshot.
also.
You see, a gunshot is there, but the thing is that it depends upon his angle of sitting. Shooting more, but one thing is very clear, he shot.
Where's the diagram over there? So he was sitting here.
Yeah, this here, and he is here.
Then
This
he-
angle.
so if he
No, television is here.
reached
TV is
there,
here.
so which
It's a genre there. Yes.
So, my lord, the story, according to the prosecution, is that there was an argument between the father and son. And in the heat of moment, he lost his temper. He went inside the room and grabbed the gun and shot him. And the excuse that his intention was to shoot the TV is just an afterthought. And I have a ruling to support that the nature of injury and the deadly weapon,
just ask
the
her.
doctor's
Okay, she
report,
explained that fully.
this all pointed to the
Okay,
intention.
see, just one question. So you said that the appellant had shot his son. Okay,
Yes,
we're
madam.
not doubting that. But how did a bullet hole? How was a bullet found on the television? Can you explain that?
My lord, it had pierced through the person and gone straight to the television.
But if you look at the diagram,
102. Page 102.
In 102.
That'd be weird. The whole thing.
no, they're trying to protect him later on. No, all of them. Hey, can't follow him holding a gun. But the daughter says that they're trying to protect him. Yeah.
Anyways, just a thought that came.
It is possible that he stood just near the plastic chair, which is at number 1. So
Any
it's a
defense
straight line.
witness?
No defense witness, madam.
Okay, let us see the 313. What does he say? 313.
Page number 3.
It is. You see the question number 2 and answer? It is correct.
It is correct. Yeah. He has replied mostly well.
You are
in this
holding a
form.
gun.
It is correct or it is incorrect.
It is
Okay,
incorrect.
but why are you saying it is incorrect now?
Correct.
If you saying it is correct, and if one is correct.
the 313 statement, he did not deny shooting the son.
Ah.
And in the last part only, he gave the explanation that he was trying to shoot the TV and he accidentally shot the son. But as Your Lordship has pointed out, this does not make any sense because at that time it was not the son who was watching the TV.
There's something is missing in this question number 5. Where is the origin? Give me the origin, the records. I put type just minute it now.
Yeah. We produce.
Question number 7, it is correct.
Yes.
Page 5. Page 5. His wife, his daughter, his daughter's father, daughter-in-law's father, they're all watching TV. Why should he go and try to shoot the TV while everyone was watching? Not
See,
possible.
we're trying to help you for the evidence. When he files an appeal, we try to help the evidence.
Yes.
But we find it very difficult.
Very difficult. Very difficult. There's nothing. There's no provocation shown.
And
See, the provocation should not be a provocation that has been going on for a long time. The provocation has to be sudden.
my lords, if your lordship could please come again to page number 102, the sketch map. My lord, here the sketch map is silent as to where the instant appellant was standing while he was shooting at the television set.
No, you see,
My lord.
the evidence shows that the sister of the
Yes.
deceased says that he saw him falling from his dining chair.
Yes.
You see, a person who has been shot, provocation and the retaliation should be proportionate to each other. You cannot have someone coming at you with a stick and you blasting him with a bazooka. Out here, there is nothing to show
There's
that
no
the son had shown any physical intimidation to the father. It was maybe they scolded each other. There was words between them. Will that justify a person blowing somebody off with a gun? Is it proportionate? That's the issue. Anyway, right. Heard Mr. Taylor Zakima, Leonard Amicus Curie. Amicus?
My lord.
And Amicus Curie also heard Miss Linda L. Fumble, edition, PP. Hearing concluded, judgment reserved.
Deeply obliged.
Yes.
My lord, in these two cases, I have to seek your lordship's indulgence again, my lord. These cases have come up after a long time, my lord. So on the last occasion, I had asked for the court to grant me some time to take instructions from clients, my lord. I only managed to get in touch with one client because the rest of them, my lord, I don't have their number. So he is going to speak to all of them, my lord. These two cases are connected. So, my lord, if I may have one more week.
What instructions do you need?
Instructions, my lord, only to ask them if they want to proceed with the case. Because this case was actually connected to another case, my lord. And these cases were kept on abeyance because of one case. Now that case has been disposed of and dismissed.
So that's covered matter.
Let
Is
me
it,
take-
if it's a covered matter, where's the question of instructions required? We'll dispose it of on the basis of a covered case.
My lord, let me, because they might want to withdraw also. My lord. I think
Then we'll list it day after tomorrow. We can't give you such time. You see, when is the judgment? In which case was it passed?
now, my lord, this case and this judgment, my lord. In fact, my lord, let me tell your lordship, my lord, the files have also been taken by them. So I am asking because my name is in the cause list, so I have got in touch with them. Now I have to speak to them, and if they want me to appear in this matter, is also another question, my lord.
Then why you then, if they have taken back the files, why are you still asking for time when they don't want to talk to you? Now, where is it? So is this WPC 14 of 2017?
But
This is the judgment passed which has been challenged.
no, that is the judgment which has been challenged. So the other case, my lord, was handled by different councils, my lord. Similar kind of issue, but different case, completely different case.
It is with regard to the Mizoram new defined contributory pension
Correct.
scheme. You want it to be declared ultra virus.
Yes, we want to have enjoyment of the old pension scheme, my lord.
Then so this has been decided by my sister, and that's his
the reason
unique
why,
vision.
my lord, day after tomorrow, I will talk to them because, my lord, I have personally asked them, my lord, to decide if they want to proceed, in which case it is most likely to be dismissed, or if they want to withdraw the case. So let me take this instruction only, my lord, only for safety.
Okay, right. Mr. Joseph Lalchandhima, Learned Counsel for the Appellants, submits that the subject matter in issue in the present writ appeal has already been decided by a division bench of this court in its judgment and order dated 17/2/2025, passed in a batch of writ petitions, the lead case being WPC 14 of 2017. He submits that though the present appeal is a covered case in terms of the division bench judgment and order dated 17/2/2025, passed in WPC 14/2017, etc. He would like to obtain instructions from his clients as to whether the petitioners would like to withdraw
Or proceed with the case.
or proceed with the writ appeals. Full stop. Last chance is provided. Next para. Last chance is provided to Mr. Joseph L. Rensei, Learned Counsel for the Appellants, to obtain instructions in view of the fact that the issues have already been decided, and as he has been what have I said? What is the last one? Last sentence? In view of the fact that the subject matter in issue has been decided, and also due to the fact that he has been given time to obtain necessary instructions from his clients as per the last two court orders. Accordingly, leave this matter day after tomorrow. Huh? Friday.
Obliged, my lord.
Friday or Thursday? Today is Wednesday.
Today's Wednesday.
Friday. You will dispose it of on that day
Yeah.
if you obtain instructions. 8 and 9 same order.
Item 10.
Your Lordship, item 10, I'll have to seek adjournment, my lord. I have some personal difficulties. If it can come up on Friday.
Daily list for motion, item 1.
May it please, let's see.
Yeah.
This is a petition under section 528 of the BNSS to set aside the impugned extension
5
of
to 8, 5 to 8 is what? Inherent power?
inherent power, my lord.
Yes, why?
To set aside the extension of investigation or
Why?
dated
Why?
because, my lord, investigation was extended by the learned
Can
special court.
investigation period be extended?
Yes, for 90 days, my lord.
And it has been extended. So what is wrong?
So, my lord, my ground is that, so while hearing the application, the accused persons were not brought before the trial court. They were not given a chance to, they were not given of being heard, my lord.
Where does it say that they have to be heard?
So,
Where
my
does it
lord,
say?
according to the Honorable Apex Court judgment,
Sure,
my lord,
let us see.
so, my lord, citation is 2022 Life Law SC 794.
Yes.
Relevant paras are, my lord, para 29, RP, RP1, RP3,
Yes.
34,
Yes.
35, and 36, my lord.
Let us see. Yes, please read.
Yes, my lord. Para 29. As noted earlier, the only modification made by the larger bench in the case of Sanjay Dutt to the decision in the case of Hitendra Vishnu Thakur is about the mode of service of notice to the application for extension.
Extension of what?
My lord,
Extension of what?
extension for investigation, my lord.
Wait, then it has to come from. Let us read from.
May I continue, my lord?
Let us go from 28.
28. Okay, my lord. Clause B of subsection 2 of section 167 of CRPC lays down that no magistrate shall authorize the detention of the accused in custody of the police unless the accused is produced before him in person. It also provides that judicial custody can be extended on the production of the accused either in person or through the medium of electronic video linkage. This is thus the requirement of law is that while extending the remand to judicial custody, the presence of the accused has to be procured either physically or virtually. This is the mandatory requirement of law. This requirement is sine qua non for the exercise of power to extend the judicial custody remand. The reason is that the accused has a right to oppose the prayer for the extension of the remand. Is that the accused has a right to oppose the prayer for the extension of the remand.
Extension of the remand.
Yes, yes, my lord.
Then
So-
carry on.
When the special court exercises the power of granting extension under the proviso to subsection 2 of section 20 of the 2015 Act, it will necessarily lead to the extension of the judicial custody beyond the period of 90 days up to 180 days. Therefore, even in terms of the requirement of clause B of subsection 2 of section 167 of CRPC, it is mandatory to procure the presence of the accused before the special court when a prayer of the prosecution for the extension of time to complete investigation is considered. In fact, the Constitution Bench of this court in the first part of paragraph 53 2A in its decision is in the case of Sanjay Dutt holds so. The requirement of report under proviso added by subsection 2 of section 20 of the 2015 Act to clause B of subsection 2 of section 167 of CRPC is true-false. Firstly, in the report of public prosecutor, the progress of investigation should be set out, and secondly, the report must disclose specific reasons for continuing the detention of the accused beyond the said period of 90 days. Therefore, the extension of time is not an empty formality. The public prosecutor has to apply his mind before submits a report on application for extension. The prosecution has to make out a case in terms of both the aforesaid requirements, and the court must apply its mind to the contents of.
Which act is this? 2015 Act? Which act is this?
TAD,
Gujarat Control of Terrorism and Organized Crime Act 2015. Do we have this act?
no, my lord.
Let us see the act. Let us see what it says. The Gujarat Control of Terrorism and Organized Crime Act 2015. Just give me section 20 of that act. Section 20. You can print, no, you can from the internet download it. Okay, you ask. Tell them section 20 only, not the whole act. Give me CRPC. We'll have to see the Gujarat 2015 Act, but he seems to have a case, Mrs. Oram Chana.
Maybe, Lordship. In the, if I'm not
You
mistaken,
see, because the judgment, have you given a copy?
no, my lord,
judgment-
I can give him a copy.
You should give a copy.
Is it Jigar case?
Jigar cases.
Oh, I'm aware, my lord.
You're aware. So, in terms of Jigar case, whenever an extension of the period of investigation is to be done,
Has to be produced, yes.
yes, so that the notice has to be given to the other side so that they can oppose that extension application. However, it was not done. So in that case, why should they not be granted bail?
As far as I know, my lord, frankly submitting, my lord, I think these still hold the field, my lord.
Yes, I think so. But I want to see that Gujarat. Yeah. They have been arrested for what charges?
Under section 21.
All commercial quantity.
Yes, commercial.
Ram Pari.
My lord,
33.
she was arrested because her bank account has been used so many times by the other
Correct, correct.
suspected person.
Only thing is that after the charge sheet is filed, if there are cogent grounds, he can be rearrested. This has been held in the Jigar case only. In Jigar case, it has been stated at this stage, we may note here that in the case of Sanjay Dutt as well as in the case of Bikramjit Singh, this court held that the grant of default bail does not prevent rearrest of the petitioners on cogent grounds
Okay,
after filing of charge sheet.
my lord.
They can always be rearrested.
My lord.
Thereafter, they can apply for regular bail. This is only for default bail.
My lord.
$22.
A question, my lord, is actually was he not produced? That is the only question, my lord.
Huh?
The only question, my lord, is was he not actually produced at the time of extension before trial court? That
No,
is
you just see the impugned order. The impugned order is at page
32 to 34, my lord.
32. 32, you see,
Yes, that is the extension order.
they are not there.
Yes.
By advocate Dill. Seen application under section 34 says so, filed by PP for on the ground says so. That's all.
Order copy was also not given to the accused, my lord.
So, there is nothing to show that the petitioner was that the petitioner was brought before the court on that day. Correct? There is nothing. You are not produced before the court.
No, my lord.
But let me see whether this. Let us see whether this 22 of the 2015 Act is same as this. Because NDPS is slightly different.
Yes.
It is 36A 4.
For my lord. 180 days was given for investigation, my lord.
But it says here different. Outside, notwithstanding anything contained in the CRPC. Yes. I think you have got some other case also.
My lord, it's cover matter in a coordinate bench of this court has already passed an order and set aside the extension order, my lord. But I do not print it out, my lord. That is the criminal petition 5 of 2023, my lord.
Criminal petition 5 of 23.
Yes, my lord.
Passed where? Here. In
Passed by
Hyderabad.
here, my lord.
Yes. Just 5 of 23, just take it out. Name it, 5 of 23. Criminal petition 5 of 23. When was it disposed of? Date?
The 19/5/2023.
19/5/23. Just take it out. Has this petitioner got any other case?
Yes, NDPS, same case, my lord.
Here, same case.
Yes, my lord.
She has got two cases or one case?
My lord, no, this is a different person, my lord. This is the first time of prosecution, my lord.
First time.
Yeah.
First time she has been.
Yes.
She has got only one case. Only this case.
Only this case.
She
my lord.
doesn't have any other case.
No, yes, my lord.
Correct. Heard, mister? Your name?
Yes, Valarkhyata, my lord.
As Vanarfyata, learned counsel for the petitioner. Also heard Mr. Zoram Chana, special prosecutor.
Yes, Your Lordship.
Special. Huh?
C. Zoram San.
C. Zoram Chana, special prosecutor. or for the
NCB.
NCB. The petitioner has prayed for setting aside the order dated 13/1/25 passed by the Special Court NDPS Act, ISOR, in NCB crime number 5 of 2023 under section 21 bracket C slash 22 bracket C of the NDPS Act, 1985. Next para. The petitioner's counsel submits that the petitioner had been arrested on which date?
8/8/2024.
8/8/24 in connection with the recovery of 2.804 kgs of heroin, suspected heroin, and 14.082 kgs of suspected amphetamine from a Bolero pickup bearing registration number TR-05/C1813 at the outskirts of Dulte village, Khozol district. Next para. How did it start? Next para. The petitioner's case is that the special court, by the impugned order dated 13/1/2025, had allowed the application of the respondents under section 36A, capital A, bracket 4 of the NDPS Act for extension of the period of investigation by another 90 days without giving any opportunity to the petitioner to oppose the prayer for extension of the period of investigation after 180 days had expired. Or completing the investigation. Full stop. He also submits that at the time when the special court had considered the report submitted by the public prosecutor for grant of extension of time for investigation, the presence of the petitioner was not procured by the special court, either personally or through video conferencing, to enable the petitioner to make a challenge to the application for extension. So he submits that the grant of extension of time given by the special court to the respondents to complete the investigation without affording an opportunity to the petitioner to make a challenge to the same, takes away the indefeasible right of the petitioner to apply for default bail under section 167 2 bracket 2 CRPC. Now 167 2 is what under the BNSS?
187, my lord.
Words are the same,
Yes, my lord. Words are the same.
which is paramateria. Give me the BNSS.
187, my lord. Subsection 4, my lord.
187. Subsection
4, my lord.
which is no, don't say paramateria, which is also provided under section 187 3 of the BNSS. It's 3, it's not 4. Four talks about custody of police. You see, it says no magistrate shall authorize detention of the accused in custody of the police under this
But,
section.
my lord, but the second from the
Unless the
third
accused
line,
produce,
but the magistrate may extend further detention in judicial custody.
Okay. No, but so, but then 3 is the one. 3 gives the time limit.
Yes,
Then 3 is the one, not 4.
60 days and 90 days.
So, yeah, 60 and 90 days. It has to be read in conjunction with that. In conjunction with 36A4.
Yes.
So, what have I said? Comma, which in turn have to be read. Which in turn has to be read in conjunction with section 36 capital A bracket 4 of the NDPS Act 1988 1985. Next paragraph. Accordingly, he submits that in terms of the judgment of the here he submits that as the petitioner has been in judicial custody for more than no, he submits that that's the no, he submits that he submits that in view of the judgment of the Supreme Court in the case of Jigar alias Jimmy so reported in 2022 Live Law SC 794. The petitioner, the impugned order dated 13/1/25 passed by the special court in NCB crime number 5 of 2023 should be set aside and the petitioner should be released on bail. Next. Mr. Sidaram Chana, the learned counsel for the learned special prosecutor for the NCB, what? Fairly submits what? Fairly submits that as the petitioner had not been produced before the. Are you sure it has not been produced on that day?
Yes, my lord. Not produced.
Should we call for the records?
Yes, my lord.
I think better.
On that
Yes,
day, they were not produced, my lord.
Anyway, we'll check. What have I said? Had not been produced before the learned special court NDPS either. At the time of consideration of the application submitted by the respondent for extension of the period of investigation beyond 180 days by another 90 days, and as no notice with regard to the said application had been served upon the petitioner, the impugned order cannot survive and the petitioner would have to be released on bail. In terms of the judgment of the Supreme Court in Jigar alias Jimmy Pravichandra Aditya Supra. Pustak. The special PP, the special public prosecutor, however, submits that liberty should be given to the NCB to rearrest the petitioner if cogent grounds are made out at the after filing of the charge sheet by the NCB for rearresting the petitioner in terms of the judgment of the Supreme Court in Jigar Jimmy Sansu Aditya Supra. I have heard the learned counsels for the party. In the case of Jigar Sansu Supra, the issue to be decided by the Supreme Court. Was as to whether the extension of the period of extension, the extension of the period of investigation was as to whether the application made by the police for extending the period of investigation by another 90 days beyond the 180 days period for completing the investigation could be allowed in terms of section 20 bracket 2 of the Gujarat Control of Terrorism and Organized Crime Act, 2015, hereinafter referred to as the 2015 Act, without giving any opportunity to the accused therein to oppose the prayer for extension of the investigation period, inasmuch as the same would take away the right of an accused to apply for default bail. Pusta. Next para. The Supreme Court in the case of Jigar Supra. Before that. Before that, you write. Next para. Section 20 bracket 1, comma bracket 2, comma bracket 3 and bracket 4 of the 2015 Act is reproduced here as follows. Okay. 1, 2, 3, 4. This one. Okay. Next para. Section 167. Oh, no, this we cannot use 167. there's a section 167, 1 and 2, bracket 1 and bracket 2 of the CRPC. And section 187, no, you say 1672, 1672 only, 1672 CRPC, and section 187, bracket 3 and bracket 4 of the BNSS is reproduced here and below as follows. Next, the Supreme Court on considering the judgments of the Supreme Court, the other judgments of the Supreme Court. What have I said? The Supreme Court in Jigar Senso Supra, while considering the other judgments of the Supreme Court, two of them being the case of Sanjay Dutt versus State through CBI, Bombay, 1994, 5 SEC 410, and in the case of Hitendra Vishnu Thakur and others versus State of Maharashtra and others, 1994, 4 SEC 602. Held that held that section 167 bracket 2 bracket B CRPC lays down that no magistrate shall authorize the detention of an accused. Provides that judicial custody can be extended on the production of the accused either in person or through the medium of electronic video linkage. Thus, the requirement of the law is that while extending the remand to judicial custody, the presence of the accused has to be procured either physically or virtually. This mandatory requirement of law is a sine qua non for the exercise of the power to extend judicial custody / remand. Full stop. The reason is that the accused has a right to oppose the prayer for extension of the remand. Thus, when there was a thus when the special court exercised the power of granting extension under section 20 bracket 2 of the 2015 Act for investigation by another 90 days, it was mandatory to produce the accused at the time when the court considered the application for extension, and that the accused must be informed that the question of extension of the period of investigation was being considered. Full stop. This was due to the fact that the extension, the grant of extension of time to complete the investigation takes away the indefeasible right of the accused to apply for default bail, and it takes away the right of the accused to raise a limited objection to the prayer for the extension. The failure to produce the accused before the court at the time of consideration of the application for extension of time would amount to violation of the right guaranteed under Article 21 of the Constitution, as prejudice was inherent. Full stop. Full stop. Next paragraph. Para 30 of the judgment of the Supreme Court in Jigar Supra is reproduced below as follows. Next para. The Supreme Court thereafter, the Honorable Supreme Court thereafter, no, para, this is para 30 and 34. 30 and 34. 34, 35 also. 35 also. Okay. $36 also. $37 also. Okay. Next para. The Honorable Supreme Court thereafter set aside the impugned orders passed by the Special Court granting extension of time to complete investigation and enlarged the appellants therein on default bail under subsection 2 of section 167 CRPC. Pusta. In the present case, the impugned order dated 13/1/25 clearly shows that the petitioner was not present and neither was her client, her counsel present at the time of passing of the impugned order. In fact, the petitioner had subsequently filed a bail application number 90 of 2025 in the Special Court NDPS, Aizawl, which was disposed of, which was dismissed, white order dated 21/3/2025. Bail application number 90 of 2025 was an application for default bail under section 187 BNSS, read with section 36 capital A bracket 4 of the NDPS 1985. Pusta. There is nothing to show. However, the bail application was dismissed on the ground that before expiry of the time stipulated for concluding investigation in terms of section 37, or in terms of section 36
36, my lord.
A.
Yes.
Now, in terms of what have I said? Just read. No, within 90 days, in terms of, within 90 days, within 180 days, in terms of section 36 36 capital A bracket 4 of the NDPS Act, the respondents had filed an application for extension of the investigation period before the special court, which was allowed on 13/1/2025 by extending the investigation period for 90 days. As such, the application for default bail under section 187 of the BNSS was rejected. Full stop. Next, as can be seen from the above order, there is nothing to show that the petitioner had been made aware of the extension of the investigation period granted to the respondent. The petitioner, having been arrested on 8/8/2024 the period of 180 days expired on
5-2.
expired on 7/8. Actually, it will be less. It will be because there are some 31 days also. Wait, August is how many days? August is 31 days. 31. September is 30. October is 31. November is 30. December is 31. So, January is 31. So, 30, 60. Wait. So 8 minus 31 will be 23. 23, then 20, 1, 2, 3, 4, 5. 150, 153, 153, 153, 6, 7, 1. 176, another 4 days. But you were sent to judicial custody when?
There is nothing on record, my lord.
Huh?
Nothing on record in my document I have applied from that trial court, my lord. So as per
No. When were you sent to jail? Judicial custody.
I don't know, my lord, because I have applied for it, all the document, but that remand order was not given to me, my lord.
You can always see from the records.
My lord, she was first remand to police custody on 10/8/24.
10/8.
10/8, my lord.
10/8 to police custody.
Police custody, my lord.
Okay, then judicial custody when? Because this talks about judicial custody. Okay, what have I said? And no, the petitioner was arrested on 10/8/2024 and was sent to judicial custody on 10. No, on dash. On dash. Full stop. As such, the. No, wait, just let me see. Okay, it says custody. It does not say. Okay, what have I said? The petitioner having been arrested on 8/8/2024. The period of 180 days would have expired on 5/02/2024. 5/02/2024. Full stop. However, the grant of extension of the investigation period by 90 days had already been given by the special court by order dated 13/1/2025. Full stop. There is nothing to show in the present case that the petitioner had been produced before the special court, either personally or through video conference, at the time of consideration of the respondent's application for extending the period of investigation. Full stop. In fact, the impugned order suggests that the extension period, the period for the grant of the extension period, the grant of the extension for investigation by another 90 days had been issued on the day the application was first seen by the special court. Correct? On the date of
My lord, yes.
in view of the judgment, no, full stop, next para. In view of the judgment of the Supreme Court in Jigar Supra, the order granting extension to complete investigation would have to be declared to be vitiated and unsustainable. Accordingly, the impugned order dated 13/1/25 passed by the Special Court NDPS Aizon in NCB crime number 5 of 23 is hereby set aside. However, in terms of the judgment of the Supreme Court, the grant of default bail cannot prevent rearrest of the petitioner on cogent grounds after filing of charge sheet if the facts so demand. If the facts so demand. Next. What's that? In view of the reasons stated above, the petitioner is to be released on default bail under section 187.
No, my lord, there has to be a separate application, my lord. For
Yes, my lord.
bail.
Along with this, my lord, criminal petition, I have submitted a bail application.
Where is that?
It is not listed today, my lord.
Oh, other.
That is bail application number 15, 2025, my lord.
We'll list it tomorrow, then list that. Is it
Mal-
here? It's pending. Why didn't you mention in the morning?
We'll take it up tomorrow, my lord. No problem.
I will take up tomorrow. Okay. You just say that in the meantime, registry to call for the records of NCB crime number 5 of 2023 from the Special Court NDPS Aizon. This is the matter tomorrow.
Well,
So then we won't say that set aside for the time being. I'll make correction. Okay. We'll do everything tomorrow.
my lord, my lord.
So we'll let this record also come tomorrow. Just say list this matter tomorrow. Whatever you type out all this, we'll pass everything tomorrow. You just say heard so, and then you say call for the records of NCB crime number so, list the matter tomorrow.
Well, highly obliged.
Item 2.
You type, I know, type wrong. You type block, I'm going to tell him. Item 2.
Coach, I'm appearing on behalf of my senior, Mr. Bilaram Benga, counsel for the petitioners. My lord, if may be kindly granted further time to file a rejoinder affidavit.
My lord,
So-
in the meantime,
Yes.
I pray time for respondent number 3 and 4 for filing affidavit.
Okay.
Even I already filed for respondent number 5.
Okay, here for the,
Yes, my lord.
Here
And
for the
state
respondent number 6.
respondent number 6, I have already
you see, the number 6 has basically said that it is used for dumping earth. You cannot force them to acquire. Okay, right. Mr.
Lomo Maralte.
Lomo Moralte, learned counsel for the petitioner. No, learned counsel appearing on behalf of Mr. B. Lal Ramenga, learned counsel for the petitioners, is granted how much time?
2 weeks, my lord. If
2 weeks time to file affidavit in reply to the affidavit submitted by the respondent number 6. Ms. Zairam Sampui, CGC, appearing for the respondents number
3 and 4.
3 and 4, is also granted.
3 weeks time. my
Is
lord.
granted 3 weeks time to file affidavit in opposition. Next, you write. The petitioner's case is that the respondent should pay damages, should pay damage compensation. To the petitioners. Amounting to rupees 9,28,74,930. Full stop. The affidavit of the respondent number 6 is to the effect that the matter pertains to the dumping of soil by construction companies on the lands of the petitioners. No, by construction companies, dumping of soil on the lands of the petitioners by the construction companies engaged under the railway projects. As per the verification report, full stop. You're for 3 and 4. You're for the central government.
Yes, my lord.
You're for the central government. Ms. Zarim Sangpuri, you're for which respondents?
Respondent number
3, 4, and 5.
That's what I'm saying.
I already filed for respondent number 5 by stating that this
But then
concern.
you see, respondent number 5, what has he stated?
Yes, my lord.
Then
That the respondent number 5 state that is concerned to respondent number 3
3
and
and 4, so you have to file.
But I still awaited the comment. That is
Okay.
I'm not.
Okay. The next para. The affidavit of the respondent number 5 is to the effect that the matter lies within the jurisdiction of the respondents number 3 and 4. Comma. That is, the Deputy Chief Engineer, NF Railway. No, the Deputy Chief Engineer, no, that's a 3 and 4, ते तो मैं रहता हूँ मैं. Who are officers of the NF Railway. On a bare perusal of the writ petition, it appears that there are factual issues involved, and as such, the petitioner would have to convince this court that a civil court is not the appropriate authority, appropriate forum to dispose of the case. List the matter after 3 weeks.
Item 3.
Lordship, I am appearing on behalf of my senior, Mr. Johnny L. Tochong, who is the departmental counsel for the respondent. He is currently out of station, so Lordship, if this matter...
No. Adjournment, what? Why do you want adjournment all the time? Both of you all. No adjournment. This matter has been pending for too long. A bail petition. Bail petition, as per the Supreme Court judgment, orders have to be disposed of within 2 weeks. This has been pending since December. What is this? Yes, what is their case?
The case is that, my lord, for the enlargement of bail of the accused petitioners who were arrested on 12th August last year, 2024, where
Yes.
the DRI has intercepted a motor vehicle, Tata Zenon, wherein the Tata Zenon occupied by 2 personnel, and on that motor vehicle they have seized 3.6 kilograms of suspected heroin, and the instant accused petitioners are just...
Has charge sheet been filed?
Yes, Lordship. It's clearly written in affidavit in opposition, page number 9, 8 and 9. Para number 12.
What is the status of this case?
Lordship,
We will take it up at 2. Be ready at 2. Yes,
Your Lordship, if I may have just one request, if I may make, allowed to make just one request for the court.
yes, what?
That, my Lord, considering the unforeseen circumstances for the absence of the leading counsels who are from Guwahati, outstation there.
No, this has been adjourned all the time on their behalf also. At the request of the learned counsel for the petitioner, matters stands deferred. This is on April 3rd, April. Then on 20th March, a prayer is made by Mr. Roshan to the learned counsel for the petitioner, having some difficulty.
My Lord, I've called his junior during the break, and he said that he's still on leg, so he requests the matter to taken up on Friday.
We'll take it up tomorrow if you want. No adjournment. Where is Mr. Johnny?
Lordship is out of station in Bilkotir.
We'll see. Let him be here. Let him come. You cannot adjourn the matter all along. This is a bail application of last year. How can it be? Right. Heard Mr.
Lomo Maralte,
Lomo Maralte appearing for the petitioners. Also heard Mr.
Michael Patrol.
Michael Pacho appearing for Mr. Johnny L. Tochong, Leonard Special PP. or what?
Departmental Counsel.
Leonard
For the
Counsel for
DR.
the Union of India. This is a bail application under section 483 BNSS, praying for bail in relation to a case registered under section 21 bracket C, flag 23 of the NDPS case, of the NDPS Act. The bail application has been pending disposal since the time of its filing on 28/11/2024. On perusing the orders passed by this court, it is seen that this bail application has been adjourned time and again on the prayer of the parties. This court is of the view that since this is a bail application where the question of personal liberty of the petitioners are involved, the councils cannot adjourn the matter time and again. As such, no further time is being given to the petitioners, to the counsel for the parties. Beyond tomorrow, that is 24. List the matter tomorrow.
your judgment.
The council should be prepared to argue the matter tomorrow.
Part 2, item number 2.